Welcome back, everyone. How was the extended break? Good. Okay, have a little bit of restful time. Yeah. I don't know. I always have a little bit of a, paradox when it comes to the breaks like that because on one hand, I really wanted to rest on the extra day, but on the other hand, I didn't rest at all because I was grading comps. The way that I described it, I was double booked because I'm also on a committee for searching for the new School of Business Professional Studies dean, and I honestly would rather be grading comps than doing that. Yeah, that's sorting through CVs and resumes, grading according to rubrics. I know that most of your academic careers are defined by rubrics, and I personally just kind of despise rubrics. I understand they serve a really important function, and I'm very, very dedicated and diligent to following them, but that doesn't stop me from hating them. I wish we didn't have to live in a world of rubrics. Yeah, this is going to be taken out of context one day, and somebody's going to record it as like, yeah, he hates rubrics. He doesn't use rubrics. It's like not what I said. I said I use rubrics very diligently, but I just don't like using them. And you notice I'm saying this language now so that if a legal deposition ever comes up or saying, what's your feeling about rubrics? I can actually go back to this video and say, you didn't hear the whole conversation. Is there a possibility that will happen? Very remote, but it's a possibility. It's a possibility. Speaking of legal stuff, we're going to talk a little bit more today about the law. We're going to talk about some topics that some are familiar, some are not so familiar. For those of you who are in seminar auditing, we're going to be talking about whistleblower protection again, because that was a topic that we've already discussed to some degree. But we're alluding back to that. Yeah, let's go ahead and get started. Um, as far as whistleblower protection goes, I obviously went to Wikipedia, which some students have asked me, why do you like Wikipedia so much? Part of it has to do with the fact that I'm just kind of I gorge myself on knowledge, on information. It's not always stuff like this. Like say, Dr. Barnes is always going to some academic website on Wikipedia, and he probably edits it too. First of all, I've never edited a Wikipedia page. But I do remember back when you wanted to find information like this, you had to pull out actual encyclopedias. So Wikipedia is like a dream to me. I don't know. I feel like a grumpy old man saying, "You guys don't know how good you got it." I had to go to the library and look at the encyclopedias when I do it. And so, yeah, but Wikipedia is a free resource, and it does a generally good job. And I do think they did a pretty nice job of describing whistleblower protection. So, according to the first resource, what is the broad goal of whistleblower protection law? So, first of all, before we actually talk about that, what is a whistleblower? As it sounds, somebody who blows a whistle, Dr. Barnes, like a referee. Yeah, a referee. No. The term kind of came into nomenclature a few decades ago, but it became very, very popular in use in the early 21st century, back when there were a lot of financial accounting scandals that were going on, and people were kind of saying, "Hey, this is a problem. They need to alert somebody." So they blew the proverbial whistle, alert that. So, what is the broad goal of these laws? Bree, what did your group come up with on this one?
Contractors calling out unethical business practices without a document.
Good. So that's a important point to know. So whistleblowers are basically saying there's a problem here. There's a thing we need to note, and they need to have freedom of speech and protection from retaliation. Those are kind of the important aspects of that. This is something that we kind of take as for granted nowadays, but back in the 1990s, these protections didn't exist. If you were a whistleblower, you were running a very, very serious risk of reprisal. And this was really problematic, not just for the company that you were working with, because if they weren't alerted and you weren't acknowledged as being a problem, then you likely lost your job. It also probably is going to be something called blacklisted. I'm sure you've heard that term before, being blacklisted. What does that concept mean? Means that you're not having a job here anymore. You're not getting a job anywhere else in your occupation. And this was a very, very common practice for people who were whistleblowers. So the whistleblower protection laws came about, and there's a lot of them, a lot of different areas. But the one I was specifically wanted to know was what regulations cover the requirement for publicly traded companies in the United States to enact whistleblower protection over financial reporting regularities. So all the accountants in the room, I'm sure they already know exactly where I'm going here. So I'm going to ask a non-accountant. AIL, what was the name of that particular piece of legislation? Yeah, SOX, Sarbanes-Oxley Act of 2002. Okay. So specifically Section 806, which we talked about, as auditing students talked about with respect to Enron, that was a direct result of a lot of the whistleblower complaints going on there. Just as this is kind of, we haven't talked about Enron in this class, but I'm assuming everybody's heard of Enron, okay? The big E, all right? The biggie. I don't know why that got a laugh. Anyway, yeah. So, what was the nature of the whistleblower complaint in Enron? So, obviously, Enron was doing something, and there was a VP of operations named Sharon Watkins, and she blew the whistle. How many times? Does anybody remember from the time we talked about it at seminar? It's like four different separate complaints. And how did that result? Nothing. They took none of her whistleblower complaints seriously. And so this was one of those ones that they had to say, we've got to do a better job about this because Enron was a fiasco. It was basically a problem there. So now moving on, we're going to talk a little bit more about whistleblower protection in a second, but let's go to the second resource. What are the federal rules of civil procedure? Now we're talking about things that accountants don't know, but what's the FRCP? Andrew, I'm going to ask you about this one.
It serves as a guide to the procedures related to civil court cases.
Right. Okay. So there's actually an FRCP for criminal procedures as well, but the FRCP nomenclature is generally considered to be for the federal rules of civil procedure. And so how a complainant can initiate a new case, how parties file and argue pleadings and motions, how discovery proceeds, and how the courts conduct trials. So all the things you want to know about civil law without actually being a civil lawyer. And so what was the overall purpose of the FRCP?
To secure just, speedy, and inexpensive civil proceedings for all cases.
Right. And so civil proceedings, again, we've talked a little bit about this. We talked a little bit about the difference between civil and criminal proceedings. Criminal proceedings are usually initiated by the government, whereas civil proceedings are initiated by third parties. And the idea being is that if there's a wrongdoing, that there should be some sort of recourse for civil parties. Now, in this day and age, if we're talking about one-on-one actions, then usually it's going to be one person versus one person, and that's our one person versus a small group of entities, and that's kind of the more commonplace. What do we call it? This is not part of the questions, but I'm sure you all know this. What do we call it when you have a big group of individuals taking a larger entity on? What type of civil action is that?
Class action.
Class action. Very good. Very good. Class action lawsuit. And that kind of came about when basically it was impossible for one individual to be able to effectively mount an opposition to a larger party, which is why class action lawsuits became so prominent. This was very popular back. They kind of came to fruition in the 1970s, though they started, I think, in the 1960s. All right. So legal deposition and trial testimony. So what's involved in a legal deposition? Isaac.
It involves allowing each side to question potential witnesses in depth, and it includes direct and redirect questions as well as cross-examination and cross.
Right. So cross-examination, direct and redirect questions are both involved in depositions. Now, we're going to talk a little bit about the nature of trial testimony in a second, but some additional aspects of it, more latitude for questioning than a trial, and less use of objections against the content and construction of questions. So not necessarily what we see in those legal dramas, but we'll talk a little bit more, believe it or not, about legal dramas here in just a second, and how they kind of constitute this fiction that we all know and love from TV shows and movies. So what is trial testimony, Joe?
Testimony that happens during the trial, and it could be direct or cross examination from both sides. It's used to present the evidence and persuade a jury or a judge to reach the final decision.
Right. So basically, it's a deposition, but a more formal setting. We talk about a trial testimony. Usually, there's not a discovery of anything, any new information. That's kind of what discovery takes place mostly during depositions, and that's why there's more latitude given. So when you see an objection or sustained argument, usually that's supposed to be coming up in the trial testimony simply because there's not supposed to be new evidence or new information presented. It's supposed to articulate the findings and the information that's given already. So what elements do these two processes have in common? Ben, I gave you the difficult question for today. So Ben's not here. That's right. Yeah, to ask him a difficult question and he just, just like a fraudster. Yeah. So who rolled for this question? Kate got it. Okay. So
They are sworn under oath, given under penalty of perjury, and become part of the official court record.
very good. Yes. Sworn under oath, penalty of perjury, and part of the official court records. So they do have common traits and characteristics, but overall they're used for different intents and different purposes. All right. So let's go on to the group questions now. So these are a little bit more of interpretation of the information. So since the whistleblower protection rules described in question one are limited to financial reporting, what recourse do employees or other stakeholders of private companies have in voicing other types of whistleblower complaints? Oh, now this one's a little bit more interesting question. This is one's a little bit more detailed. Bree, I feel like had you answer the first whistleblower question, so I'm going to actually switch it up a little bit. I'm going to go back to Ben's group. And so who's got this one? Tyler.
Yeah.
Tyler. Okay.
So we said that it depends.
Okay. Good answer. Good answer. Always a proper answer in my classes. Yes.
We said that it depends on what the employee is reporting. A lot of situations have associated whistleblower protections, such as through OSHA or the EEOC, but a lot of others don't.
Right. And so, yeah, EPA, OSHA, those are all good observations. They're not formal whistleblower complaint agencies, though, or at least they don't have formal whistleblower protection, but they do carry enough weight that they can actually be used as whistleblower organizations. There's also some additional remedial actions through like labor unions, collective bargaining, and issuance of grievances. But there's the question that we come up with in this next question is lack of structured regulation in this area a cause for concern with respect to the effectiveness of investigative proceedings? Why or why not? Joe, what do you think?
We said yes, the lack of structured regulation for private businesses and private contractors is a major cause for concern regarding effectiveness of the investigations. Article says that employer activity that's not prohibited by law is usually permitted, which means without the strict structured regulation, a dispute or investigation may fail because the whistleblower can't cite the specific law that was broken.
Right. So I think the term that I used to describe this is a lack of operational integrity. And it comes down to one of those things that we talk about a lot in accounting is that we're very, very concerned about how things appear on the surface, but the lack of whistleblower protection for the operations of the organization may be problematic because the operations are what make up those financial statements. So if the financial reporting is wrong, there's already requirements in that area. But are we just concerned about financial reporting from a fraud perspective? Are there operational concerns? Like, I'm going to use an example from my favorite TV show, Walker, Texas Ranger. Okay. Say you're using subpar materials on a construction job. Is that something that could be considered fraudulent? I would think so, because if you talk about worker safety and you're basically trying to come up with something that was probably agreed upon in a bid, and your bid was based on using proper materials and something that's going to be safe and compliant with existing regulations. So subpar materials, I think, could actually be argued it would be fraudulent from both a criminal and civil perspective. Okay. By the way, great episode of Walker, Texas Ranger. I highly recommend you checking it out. Okay. The construction episode. Yeah. When you have Chuck Norris as a construction guy, I'm surprised the building did not get built in a day. Yeah. So, yeah. Anyway, so yeah, I think there's some problems with, we talk about lack of structure, regulation, and operations. There are organizations that follow these protocols, but they are not necessarily as effective as we would think about with respect to financial reporting, whistleblowing. All right, so recall last week in litigation or legal action may be criminal, civil in nature. What is the fundamental difference between criminal and civil action? I already answered this question earlier. We talked about this last week. We said that criminal action is mostly initiated by governmental organizations and it's supposed to be punitive in nature. To what organization or what group, what entity does civil or do penalties in criminal actions go to? They go back to the government, okay? Go back to the governmental organizations. So the fines, like we talk about for financial reporting, if an organization makes a mistake or not a mistake, if they commit fraud in financial reporting and they're penalized for it, usually they have to pay fines to the SEC. So that'd be an example of that. Civil action, this is more about, what is the term that I used? Is more about committing wrongdoing. Okay, so the wrongdoing is committed. Generally, the bar for identifying wrongdoing is much lower than trying to identify actual criminal action because it's a little bit more subjective in nature, and wrongdoing can be a little bit more about opinion-centric rather than whether or not somebody broke the rules. And so punitive actions generally going to be monetary, and they're going to be benefiting the injured party. So we talk about criminal actions. If you were somebody who got defrauded in a big financial fraud scheme, the SEC may require their share, but you can actually demand your share through a civil action, and that's going to be trying to recover something that you lost as part of that opportunity. And then speculated some reasons why specific rules related to civil procedure are necessary. So why do we need different rules for criminal actions versus civil actions? This is a pretty interesting one. Isaac, what do you think?
We said specific rules related are necessary because they standardize procedures for producing evidence, simplify pleading requirements, and promote fairness and efficiency of trials.
Yeah, good. Okay. So given that the objectives they're substantially different, I mean, they do align to a minor degree, but again, that we're trying to identify wrongdoing as opposed to criminal action, that we're trying to redress for losses as opposed to just penalize and being punitive in nature. There's certainly going to be differences in the nature of the operations, so there should be differences in the rules that are associated with those. So that's again fairly intuitive. One of my favorite words to use. Fairly obvious why there should be different rules, but I think we need to articulate that to come up a little bit more detail and issue. All right, one of the things that we need to talk about with respect to the rules under the FRCP has to do with e-discovery. Now, when you saw these rules that were listed in the this source that I sent you, like Rule 26 and Rule 37 and the Rules 37E, did you all just kind of lose it right at that point and just kind of stop talking as a group and just read diligently in detail? I know the group that was in here did. I was trying to interrupt them. They're saying we're busy reading rules right now, Dr. Barnes. I gotta stop. Yeah. This is riveting reading. So obviously I'm being facetious, which is why I would never become a lawyer because they have to be able to read like that. But then again, I did read academic literature for 5 years, so there's that trade-off. So let's define e-discovery, then let's talk about the rules because the rules are important, though they are a little bit dense. All right. So what is e-discovery? EIL, I'm giving you the easy question here. Okay. So I want that noted in my record. All right. So what is e-discovery? Right. So using technology to manage digital evidence, like you said, emails, documents, and database. It's a good identification. Generally, we're focusing on electronically stored information, or the term that they tend to use is they say ESI, just because it's a kind of a catchphrase. But how do we actually aggregate that information? How do we collect it? How do we store it for use in the future? E-discovery, really, really important this day and age because we are a technologically based society now, or we do operate very heavily. There was actually a reference back to case that we talked about earlier, Theranos. Does everybody remember Theranos from early on? So one of the discussions in the book, Bad Blood, was of executive Don Lucas, so was his name. He was a very well-known investor, and he refused to operate via emails. He would only have discussions face to face. He would never have discussions over the phone, over email, because he was paranoid about e-discovery and basically this information being used against him. This has also been very interesting in for me personally in the dean search when we were talking about the use of a rubric. And one of the things that I was told by the parties at Truman State is that you have to be very, very careful on what you articulate in your notes, because we were taking notes about our rankings, about who we recommend for the party and everything. Anything that's written down or put into the electronic document can actually be used in the future, can actually be noted in the future, which is a real problem for me because you know how snarky I like to get on my commentary, okay? I have had zero snark whatsoever. It's been killing me. It's been absolutely killing me. So you have to be very, very careful because of e-discovery in these items. If I just made a snarky comments like, this is so boring, they could come back and say, oh, it looks like one of these guys didn't take this seriously. It's like, no, it's very, very boring. I just do take it seriously. Again, for legal reasons, that's why I'm making this disclosure. All right. Yeah. I'm being very, very careful. Very, very careful. So it doesn't stop it from being boring, though. All right. So briefly summarize the rules under FRCP and the practice of e-discovery. We talked about the rules, but let's see if we can briefly do it. Andrew, counting on you. Can you briefly summarize these rules for me?
Rule 26 establishes practices for discovery of physical and electronic information.
Good. All right. What's the other rules?
37 outlines the potential penalties for non-compliance with Rule 26.
Right. Okay. And there's a subset of Rule 37 that basically talks about sanctions that should be applying specifically to failure to preserve electronically stored information. And what is this relevant to? We talked about the storage of information. What is this relevant to something that's been talked about, at least with the accounting students, which I'm sure it's relevant to all the students, but specifically with respect to accounting? So archiving audit findings. Remember, we talked about that not too long ago in seminar and auditing. And those of you who are not in seminar and auditing, you should still remember it from 417. But archiving information, really important. Why? because we're talking about an actual legal operation. If we're talking about a financial statement audit, this is something that's required in compliance under the law. So we have to actually follow the same legal rules. Now, is this the guideline that we follow as auditors? No, but it's very closely related to that. There are certainly going to be penalties if you do not follow the rules. If you do not follow the rules with respect to making sure you archive and retain information for a period of time required by law. So very similar to what we've talked about in that context. Okay, my favorite question of this. So based on your definition from question 3, describe the circumstances in which legal deposition may be employed. Bree, I got you a law question here, so yeah.
Legal deposition, pre-trial discovery phase to help uncover facts, test witness credibility, and get an understanding of the case before it reaches a court.
Good. So basically, when we're trying to find information and trying to do something without information from one of our parties, we can develop a comprehensive analysis without information from one of our parties who can bear witness in the dispute. So just basically, this is fact finding. This is trying to both parties trying to actually determine what it is, what are the constraints, what are the boundaries, what is the information that can be gleaned. And we tend to have a skewed view on this again because of our cultural perspectives on law. But the idea here is this is where the majority of gathering information comes up. This is where the majority of gathering information. Nothing really comes up within the trial. And that's going to kind of answer the same for trial testimony. So let's go ahead and I'm going to mix it up here. I'm going to say, Isaac, what is the circumstances for trial testimony?
Trial testimony is used during trial to present evidence to a judge or jury.
Okay. And so this is basically where we already have the information that we need. We're trying to provide context or direction and trying to actually determine whether or not facts exist, fact patterns exist, or fact patterns do not exist. And so trying to make the determination, what are the facts and what do they portray with respect to the guilt or the innocence of a given party, and with respect to civil actions, wrongdoing that's committed by a given party. So a bit of a different approach. Now, this is what the question. This is the part of the question that I really like. Okay, and Bree, I'm going to go back to you for this since you're our future lawyer here. So. Media incident, the majority of witness testimonies is taking place as part of an organized trial procedure. Do you think this is an accurate representation of what happens in reality?
Not. Because most cases are settled before trial, testimonial answers are given for the trial, so what people on the stand say is like expected to their constant surprises that we see.
Right, yeah. So there's not really any swerves. The expectations for trials are pretty much laid out. Then now we may say the expectations for what the jury or the judge finds in a trial are not necessarily derived, but the expectations of the information that's presented are pretty much a given. So just basically, why do you think that media films and cinema tend to portray trials the way they do? That's right. It's more dramatic. Yeah, it's more interesting. It's the problem is like if you grew up on watching trials on TV shows or trials in movies and saying, I want to be a lawyer because of this, I feel like bad news for you is that this is not what law looks like in the real world, which may be a letdown. And so, yeah, this will be an interesting question to ask Ken when we talk to him in a few weeks. It said, so you became a lawyer. Was it all you thought it would be? And he's probably going to say, no, there's a lot more boredom in there associated with that. But to be fair, when you get into a lawyer, there's still a certain amount of excitement. And when you get into accounting, you know exactly what you're walking into. Okay. So yeah, there's that. According to the ACCT Fraud Examiner's Manual, there are 2 general categories of testimony, lay testimony and expert testimony. Briefly explain the difference between these 2 categories and describe situations in which each type would be relevant. So EIL, what's lay testimony? Right.
Who things information. So they're used the lead witnesses used describe what happened while the experts help the court when there's times.
Good. So basically, lay testimony is saying these are the facts. Expert testimony is like trying to provide interpretation of the facts. One is very objective, where the other one can be somewhat subjective. So let's just go ahead and run through an example to make ourselves all experts in this particular context. All right. Did you see Dr. Barnes steal the snack cart? Is that lay testimony or is that expert testimony? That's lay testimony. Okay. So then expert testimony, it says, can you speculate on why you think Dr. Barnes stole the snack cart? The answer would be he owns it. He owns it. So that's his card. He can put it in his office if he wants to, and definitely steal the snacks if he wants to. Yeah. So that's gonna be the goal. I only mentioned that today because the snack cart's not out. I forgot to put it out today. So my bad. My bad. Okay. All right, we are done for today. Thursday, we've got Russian laundromat and final case results.
We'll try to